Very well. Very well. So the first question we want to pose right now is who owns the property acquired during the marriage? And I would like to start with Senior Kennedy to help us, break it down. Who owns property acquired during the marriage? So if we have a couple living together and they acquire a property in the course of marriage or during the subsistence of the marriage, who owns it? Senior, can you help us? And I'm sure when we are done, we'll open up for people to ask questions. And
thank you, Councillor. And NUPS G to us all. Yes, good evening. There are two ways or two sides of this coin, this particular question. Who owns property acquired during marriage? If it was acquired with the intention that it should be for the couple to the married, the two spouses, then it is for the two of them. If it was acquired with the intention, one spouse acquired it with the intention that it is for just that spouse, then it is for that spouse. So the critical thing to look out for is the intention of the couple when they were acquiring the property. What was their intention? Were they acquiring a property to be for the two of them, or one couple or one spouse was acquiring the property for him or herself alone?
Okay.
So that would determine who owns it. If the intention is that we are acquiring our matrimonial home, we are contributing, we acquiring a house, we will build our home where we intend to live as couple, then it's for the two of them. But if one says that I've seen some property at this location, I'm interested in buying it, and I want to buy it for just myself, then that is the intention. So then it will remain like that.
So it means the intention plays a very important role here.
Exactly.
Very well. So is a spouse entitled to property they did not directly contribute? Senior Susan, if you fail to contribute money towards a property, are you entitled?
As they say in law, everything depends. So there are certain circumstances in which you might not have contributed physical cash, but you would be entitled to. For example, let's say the understanding between a husband and a wife is that the wife would look after the children, do all the housework, support her husband any way she can. Maybe the building project, she was a supervisor and all that. She might not have contributed financially, but you'd realize that she has contributed by her work at the home, by her marital duties, by looking after the children and all that, by supervising the workers who are building. She has contributed, or he has contributed, depending on who the working spouse is. And so in such circumstances, the court would look at the circumstances and say, considering all she has done, it is work. If it had been valued, this is how much it would have cost, and this is how much it would be. So the court would assess, and there will be a percentage. There are certain circumstances also, you will not be entitled to anything because you did not contribute anything. And like Ifa said, if the property was meant to be personal property and not joint marital property, then you can't say you are entitled. There was a time where the court was not differentiating between personal property acquired during marriage and was considering all properties acquired during the marriage as joint marital property. But over the years, the court has made certain distinctions because it has created a bit of confusion. So now the courts have held that you can acquire personal property during the marriage, which would not be considered marital property. In such a situation, yes, it was acquired during the marriage, but one spouse will not be entitled to it.
Okay, so you use the phrase joint property. And so let me ask this question. What it means that is a joint property and there's also a separate property. So how does the court determine joint property and how, or versus separate property? How does the court determine joint property versus separate property?
So it is like if I said, the intention behind the acquisition. So if the intention is clear that he was acquiring the property or she was acquiring the property for personal use within the marriage, still it will be determined as. But if it is the intention is clear that the property is being acquired for both of them, for example, the land was bought in the names of both parties or with finances from both parties, it is obvious that it was not meant to be personal property and it's joint property. So the intention is quite critical in such situations. The court would look at it.
Very well. Very well. Okay, so Sinefa, if you can hear me, can a spouse claim property purchased in the other spouse's name? Can a spouse claim property purchased in the other spouse's name?
Yes. Let's first of all say that property can be, in law, we look at property in two ways: movable property and immovable property. The movable property are those, so let me define the immovable rather. Land and landed properties are immovable property. Any other property is movable. So cars, clothing, gun, jewelry, whatever, they are the movable property. Immovable, land and landed property. Now, with the immovable property, that is the land and houses and estates and things like that, the position of the law, if you look at Section 38 of the Lands Act, the position of the law is that even if the deed, the instrument, that is the document on the land, is in the name of one spouse, unless in the content of the deed, in the content of what we normally call the indenture, or the popular name we give to it is the indenture. Unless within the content of the indenture, it is written that this property is just for one spouse, even if it is in the name of just one spouse, it's for the two of them. If you look at the provisions of Section 38.3, 38.4 of the Land Act. So that is with immovable property. That's the position of the law as expressed in the Act, that so long as they are married couples acquiring immovable property, until you put it in the content of the document that this is for just one couple or one spouse in the marriage, the law sees it as being for both of you. So even though by the title deed, the document, indenture, it is just one spouse's name, one spouse's name which is on it, the law sees it as being for the two of them. For the movables, there is no such provision. So for movable property, if it is car, if it is the property is for the one whose name is on it. But for immovable, the Lands Act makes it for the two of them until you indicate in the document that no, this is just for me. I have explained it to my husband, my wife, and we have that understanding that I'm acquiring this property for just myself. If you don't have any such thing in the body of the indenture, then the law sees it as being for the two of you.
I see. So it has to be express.
It has to be express, yes. If you want it alone, it has to be express. But the presumption is for joint.
Mm.
The law presumes joint until you expressly indicate that it is for you alone.
All right.
For
So we are addressing
properties.
Okay, Senior, are you done?
Yes.
Very well. So we are addressing marriages acquired during the subsistence of the marriage. But what happens to a property acquired before the marriage? Senior Susie, can you help us? Before the marriage.
The law has always been clear. Properties acquired before the marriage belong to the party who acquired it. And sometimes people get a bit confused and think if they marry a rich man or a rich woman, they will be entitled to their properties. Unfortunately, it is not so. The law looks critically at properties acquired during the marriage as marital property, not properties that was acquired by the individual before the contract of marriage was effected.
Okay.
Yeah.
That's very clear. So if I'm getting you, if I had 20 houses before I got married, my wife has no share in it, unless I decide to maybe give her a number of them. Is that the case?
Yes, which is also your prerogative.
Right. Thank you very much. I'm sure we are jotting down our questions. When the time comes, we'll open the floor for people to ask questions.
Let's also add that, you see, if any of the 20 properties you had before the marriage were uncompleted, and then your spouse joins you, your wife joins you, and then
yes,
the course of the marriage, both of you complete the uncompleted ones.
Yeah,
it becomes jointly acquired.
Okay.
Okay. So we should make
story
that
building.
distinction.
So what if it's a story building? I completed the ground floor, but the first floor was not completed when we got married, and my wife comes in to put in money to support me get it completed.
The whole property becomes jointly acquired then.
Although I had finished the ground floor before.
Yes, it's one property.
I see. All right.
So if I may just
yes,
in,
coming.
That is where when you appear before, that is when you appear before the court, you see one party trying to define that there was differences in contribution, and so there should be a separation in the distribution. So then the court starts looking at the various contributions of the parties and also ends up dividing it, not according to the 50-50, which is normal, but would change the percentage, sometimes looking at the contribution of each party. There are situations where the courts cannot see that it is on the equal footing. They have come to the conclusion not to divide the properties equally.
That's very clear. That's very, very clear. Thank you, Senior. So we'll continue. I'm sure more questions will come as we progress. So in this instance, does domestic work or child care count as contribution to marital property? I'm not putting money in it, but I serviced in the house. I took care of the children and did domestic work to support the marriage. Is it counted as contribution to marital property? Please, any of you can take it up.
Historically, there was a time it wasn't, but from about the 2005s coming, I do not want to bother my non-legal friends with the plenty cases that we have to put in our head. From the 2005s coming, the courts considered household chores, marital duties, all that as contributions to the marriage. Over the years, there have been slight changes to the positions, and we've been going a bit back and forth.
Yeah.
But it hasn't been totally ruled out as being a contribution to the marriage. Once it is put in evidence that this is what I did, the courts would look at it and put a weight on it as a contribution.
So is there a mathematical way the courts assesses non-financial contributions, or it's just something that the judges themselves they use their discretion to come out with?
You know, there was a time the Supreme Court said equality is equity. And so a lot of the courts were following the 50-50 formula. But there have been changes over the years.
So
when
that's the case
they
of
say
Mensa
that,
and Mensa.
yes, they'll say, look at it case by case. And in fact, in the latest Supreme Court case, that is what the court is advocating, that it should be on a case by case basis. Look at the evidence before you and determine who should get what. So it keeps on going up and down. The law keeps on changing as to how it should be done. But it hasn't been ruled out that household chores and spousal duties that occur during the marriage can be seen as contribution, which can be quantified for financial contribution purposes.
Very well. So then I ask this question: must a spouse provide receipts or documentation of their contributions? Do we have to keep records to show that this is my contribution to the marriage? Must a spouse, Mr. Ifa, if you can help, must a spouse provide receipts or documentations of their contribution, to the marriage?
Yes, where we are now, if you look at the recent case of Abner Pokua and Yao Pachi.
That recent one, December 2025.
In the media and all that.
Yeah, it's all over.
Where we are now, it is in the best interest of the spouses to do that.
To keep receipts.
Yes, to take some evidence. There should be evidence of your contribution. These will include receipts, pictures, if you have your bank account, the bank statements, Momo statements, anything that showed that indeed money moved from you to the other spouse for this purpose. Where we are now, where the law is going, like Susan explained previously, once the property was acquired during the marriage, it is seen as being for the two of them. Now, the position of the law is that that is not the law anymore. You, the party that is saying the property is for the two of you, must show evidence of your contribution. So the only and so your however you are contributing, you must show the evidence. For instance, if it was your duty to go to the site, feed the construction guys who are working, take some videos and pictures of you at the site doing what you are claiming you are doing. So it is not just receipts, but any evidence that shows that, yes, you contributed in the acquisition of this property. You see, you contributed in the acquisition of this, is fine. So yes, where we are going, don't just hand over cash to your spouse. We are going to buy land at Apollonia. You hand over 50,000 as your contribution, and then that is it. No evidence, no receipt, no nothing. Where we are going now, if there's the marriage should be dissolved along the line, and you are claiming that the Apollonia house is for the two of you, it will be difficult to convince a court with just your oral claim. And so where we are now,
documentary
it requires
evidence
that when couples are supporting each other with money meant for property acquisition, then some form of receipt must be taken. If you are transferring through the bank, it should so the best is to give a check That one, you can always get your bank statement, print it out, and show that this is money flowing from me to my partner.
So documentary evidence is very key, if I should get you right here.
Yes.
Because it's the best form of evidence.
Exactly.
Yes. Please, I don't know how to, but if you can show your faces a little bit for us to see you, I'm sure it will make the thing nicer. Senior Susan, I've seen you. You see, you look so beautiful. The others, Mr. Felabi, Mr. Nkama, we want to see your faces. It's like I'm the only one whose face is showing. I see Osofo Ima Tete is here. I see Mr. Basanio. I see the bloggers are all showing their faces now. I see most of our seniors here. Very well. Okay, so I'm sure we'll continue with the the next phase of questions, which is about divorce and property sharing. Which is about divorce and property sharing. So, how is property shared upon divorce? Senior, can you help us? Senior Susan.
Just before I get into property shared, you see, as we are saying it, we don't want people also to be mercenary in their marriages and think that their marriages are ending.
So that's one thing.
And so everything is no. It's just that let's all understand that anything can happen. Even sometimes when death occurs, there have been conflicts between the family and the spouse who has the surviving spouse. Sometimes all these are things where, so it's not just because you think that your marriage would end. No, it's just sometimes to protect the marriage so that both parties know that this is how it is going. I mean, when both know where they are standing, sometimes it helps. You know, money is always a problem in marriages. So please don't make this a problem in anybody's marriage. We are only saying when the marriage is over, but don't make it a problem. Just be eyes open. Thank you. Now I have said that. You say how is property shared. So the courts normally would take evidence. They would want to know what you've done. They would want to know what you've contributed. And that is where the receipts come in, the pictures, the text messages, the ups and downs, all those things. That's where they come in. You see, there's something funny. Unfortunately, there's a lot of acrimony when marriages end. And nobody wants the other to enjoy, so to speak. Everybody wants to take the majority for themselves. So even though you are Christian, there are times you'd see that some of the parties are telling patent untruths. In situations like that, my word against your word, the judge is like, okay, who sounds nicer? And it always doesn't help. But if you are able to show that this is it. So on this date, I took 5,000 from my account. I used it to pay the workers. I transferred the money electronically. This is it. I think it is also an admonition for us to also have quite a bit of electronic transactions. That one speaks for itself. So you don't have to be in the marriage and thinking, hey, let me put down my receipt. Hey, I put 5,000. But if you have sent mobile money and of course the reference, you write workers' fees and things like that. On the unfortunate day that it is called into question, I mean, bringing out those things will help. But one thing the court does is to look at the evidence. Something must show, especially if it is being denied by the other party. Especially if it's being denied by the other party, something must show. Yeah. So that's what the courts will look at. The courts will look at, and of course, if you do not present it in evidence, the courts would also not be able to consider it. So that's another. You must be able to present it, and it must not just be an offer as they say. I've said it. No, if somebody brings a counter, you are in trouble. So
it throws away everything.
Yes. So it is what you present to the court.
Let me
help us. Yes.
Let me add that when it comes to what the spouses get if there should be a divorce.
Mm.
If you look at Article 22 of our Constitution, it says Parliament should pass a law on it. Immediately, the Constitution comes into effect, Parliament should pass a law on it. It has not been done.
I was going to ask.
Parliament has not done. The bill is in Parliament. It has been in Parliament since, if I'm not mistaken, since President G.G. Rawlings' time.
Yeah, that's correct.
1992
And
today.
Yes, and it's been there.
Mm.
It's not being passed.
Mm.
Not being passed. That law is not being passed. So what happens is that it is the judge, the presiding judge on the case, that determines what the parties get.
Yeah.
It's entirely at the discretion of the presiding judge. So let's bear that in mind. There is no set of rules that determines it. This is what you provide the judge with, the evidence you give to the judge that comes to determine what you get. So if, assuming that the properties are valued at, say, 4 million Ghana cedis, and you were able to prove to the court evidence of your contribution of just 60,000 Ghana cedis, the presumption that is what you have brought in. And so you are going to get a proportion to that.
Okay.
A proportion to that. So
exactly.
Let's bear in mind that judges don't have any rule. Parliament hasn't passed the law yet. We don't have any rule for determining what a spouse gets upon the dissolution of the marriage. Yeah. It is entirely a discretionary thing. So you must assist the court with your evidence of contribution.
Yeah.
If not, proportionate distribution will be done, and it may look as if it is so unfair. After 20 years, 30 years, 25 years of marriage, this is all I get. But it's all evidence, and you must lead very strong evidence to that effect.
I think at this point we need a notebook, like somebody wrote here. Also for NSA, because you started quoting laws. Let me ask this question for Reverend Emmanuel Kwame Tete. He says, kindly help me reconcile this. Papa Ifa mentioned that the law presumes joint ownership of immovable property unless it is expressly stated. Mama Susan also referred to the law indicating that the spouse has to prove his or her contribution to the accusation of the property, whether cash or kind. Now, where does the burden of proof lie? Is it with the one with the name on the property deed to prove that the other did not contribute, even though the law presumes joint ownership? Or the burden only lies on the spouse with no name on the document to prove contribution?
Okay.
This is a question from Osofu Tete.
Okay. So, you see, the law is a funny thing. The burden, it shifts. It can move to this person. Then this person would say, then it can shift again to the other person.
You also prove, yeah.
And you also prove. And let's say there is the presumption that it is joint property. There is a presumption that it is individual property because of certain things stated. But before the court, those presumptions can be rebutted.
Yes, anytime.
So let me give an example. You have a joint account. Unbeknownst to one of the parties, one takes money, goes to a private property, puts it in their single name, forges a document, and says the other spouse is in agreement, signed it off. Then the marriage ends. It comes to court. The woman or the man is like, that is joint property. The man says, look, your signature is on it. Now it is for who to prove. So it will come to the woman. You say what? She will bring her evidence. It will shift to the man. This is what the woman says. What do you also have to say? Then it keeps on going till the court can make, back and forth to the court can make a determination. So yes, you see some of these things, The Lands Act is 2020. It has said it. But despite what the Lands Act has said, if there is enough evidence to show that it was otherwise, sometimes the court would look at it and for equity's sake would balance it out and not strictly follow the law and say, this is what the law says, even when it is clear that somebody was trying to do a bit of twist of hand. The courts look at so many things in a divorce. That is why sometimes it can travel all the way to the Supreme Court, just like any other matter, because there are differences in opinion. You agree with the judge, you disagree with the judge, you think that it hasn't been done right, you go on. So what do I normally tell people? It's like when property is being acquired, acquire some, let it be joint property and contribute fairly, so that when it is being shared, you get your fair contribution and not say that you went to sit in a marriage for 20 years and you didn't get anything, because it might end up being truly you sat in the marriage for 20 years and you contributed nothing. And the court will come at and say that, yes, it is in both of your names, but I'm still going to share it 80-20. It can happen.
I see. So my next question is, what happens if the couple was married under customary law instead of ordinance marriage? Do the rules apply in both types of marriages? Is there
Yes. So marriage under Ghanaian law can be contracted in 3 folds. You can marry under customary law. It's accepted. It's marriage. It's marriage under Part 1 of the Marriages Act. You can marry under Mohammedan law or Islamic marriage. It's accepted. It's marriage under Part 2 of the Marriages Act. And then you can marry under what we popularly call ordinance, which is marriage under Part 3 of the Marriages Act. Any of these 3 modes of contracting marriage is accepted under Ghanaian law. And once the marriage is accepted, that is marriage. There's nothing like this one is customary marriage, so then we will treat it this way. This one is Mohammedan marriage, so we would know. It's a question of, are they married or not? Once it is established, it cuts across. Once they are married, it cuts across.
Okay. So what can actually deny a spouse a property after divorce? Can a spouse, let me put this way, can a spouse be denied property after divorce?
Yes, it can happen. Yes.
Completely.
If you are not able to show, you see, let's say, look, there have been times, there was one of the cases, one of the judges in his ruling was practically seeming to complain that some people think that they can just come and stay in their marriage and after a few years walk away with half of the property acquired when they have been, so to speak, trophy wives. No, the courts are not helping trophy wives now. So if you want to be a trophy wife and think that simply by coming to sit down nicely under the marriage,
they only happen in telenovelas.
And be a beautiful wife. There's a maid servant. Everything is provided for you, and you think that you are just sitting there to be beautiful, and you will walk away. On the day of the divorce, you will receive the shock of your life, where the judge will tell you that you have proven no contribution.
Yeah.
And it has shown clearly that you only benefited from the marriage. Yeah. And even now, the courts are not even so keen on the old provisions. That's where in the Matrimonial Causes Act, where they had interpreted it to, they'll give you the necessary financial provision or keep you in the same state as it was in the marriage. The judges have leaned away from that. So if you think that's well,
NT, no contribution, no chop. If I should
practically, Presby welfare.
Yeah.
Yes,
which you have abandoned.
in that, let's also clarify that
Mm.
in determining contribution to property acquisition, the law and the courts allow a lot of things to come in. It is widely interpreted. It is widely received. You see, the court, anything can count towards contribution. Let's also not forget that aspect of the law. It is not straight. It is not narrow.
So senior, what then
So-
influences the court's
so-
discretion? I'm not cutting you. What influences the court's discretion in distributing the property?
That is what we are saying is that you must show contribution.
Mm.
You must show that there was an intention to acquire a matrimonial property.
Yes.
And the way of showing it is to produce some form of evidence. And we are adding that the evidence is broad. If you look at the position of the
Very
courts
broad.
and
Yeah,
all
very
the authorities that are available to us,
Yes.
it's very broad. In fact, in the case of Mensah and Mensah, the Supreme Court said that if a wife dresses well,
Mhm.
to
Mhm.
even follow the husband around, for the husband to feel good, this is my beautiful wife. It is contribution. It is contribution to the marriage
So
or
dressing
to
is
the
even,
property acquisition.
dressing can be a form of contribution.
Yes.
Well,
Now, if you take a
yes.
couple,
Not to cut
that
you,
okay.
but what as he's saying, especially if you carry your beautiful wife to meet you, so that people will come and meet you and bring you business, it's her contribution.
Yes. And if you take couple that do business together, so they have a family business, both of them are working there. Probably the husband as the MD, the wife as general manager or administrative manager or something. And then they are acquiring properties from the income of the business.
Mm.
That is contribution. That is contribution. So the court recognize so many things as contribution to the marriage. So the fact that we are saying that you must prove contribution doesn't mean that you at the least you say, well, I don't have any evidence. So then so many things count. The court recognize so many things as contribution. So you just need to lead evidence on those things.
I'm grateful. So I'm enjoying the program today. So far we have over 21 participants. I'm sure you are all jotting down your questions for us to continue. However, we'll continue, and the next I will ask a few questions, then I'll open up for everyone to come in. So let's talk about marital property itself. What qualifies as marital property under Ghanaian law? Are gifts and inheritances received during marriage considered marital property? So my father decided to give me a house. My father decides to give me a house while I'm married to my wife. Is that considered as marital property? Or my wife's father gives her a house? Can I say that I have a share in it?
Okay, so let's start. First of all, the property should have been acquired during the pendency of the marriage. That's the first thing. So that is using time to determine. So one, when was the property acquired?
Mhm.
Property acquired before the marriage, after the marriage are not marital property straight away. Then the properties acquired during the marriage, gifts and inherited properties are not counted. If there's a gift to one spouse, then clearly the intention is to that spouse, unless the gift is to both. So if there's a gift of property to one spouse, the one who gave the gift intended that it should be for that particular person. So it's not marital property.
It's not meant for the couple.
Yes, because the rule is to look at the intention. What was the intention from the beginning at the time the property was being acquired? So inherited properties too are not. If one spouse's parent, passes on in the course of the marriage,
yes,
and there's distribution, and then
distribution of property,
the
yes,
person gets some property.
from
The
his
intention was not that it's for, that person and the wife or the husband. So they are also not included in marital property. So if you then narrow it down, you are looking at property acquired by the couple themselves with the intention that this is for the two of us. That is what counts as marital property. Okay. So even if it was acquired in the marriage, you have to look at the intention. What was the intention?
Thank you very much, Senior. So let me ask this question to Senior Susan. So we are separated. Okay. We are not divorced. We are separated for a while. Does property acquired during separation count as joint property? You know, it's only the court that can grant divorce.
Yes.
So we may have issues and we've been separated for some time, maybe like say 2-3 years or 5 years. In between the times, I acquire a property to myself. Does that count as joint property?
So you see, we come back to intention.
Okay.
Was the property meant to be marital property? Yes, it was acquired during the marriage. You were separated.
Yes, but it's during the marriage.
It was during the marriage. But you see, even property acquired during the marriage, there have been times when, if the intention is clear that it is not meant to be marital property, it is separated. It is not considered marital property, which is why the courts have said that it is possible to acquire personal property even during the subsistence of a marriage, but the intention has to be clear.
Okay.
So, but of course, let's remember that you and your wife bought the property, you built to maybe roofing, then you separated and think that because you finished it, it is yours. The courts would also look at the contribution aspect. So there's so many things the courts are looking at. In divorces, there is no formula. There's no A, B equals C. The courts would look at the evidence and determine on case-by-case basis.
Okay, so this question.
Let me add this.
Throw more light.
Let me add this quickly that Ghanaian law does not know separation or half-time or commercial break in marriage. Ghanaian law doesn't recognize separation. In America, you may find it. In UK, you may find it. But Ghanaian law doesn't know separation. That the parties are not living together. They know. In Ghanaian law, we have marriage and no marriage, period. So you are either married, it's either during the marriage or after the marriage or before the marriage. So there is nothing like separation as you find in other countries in Ghana.
So there's not like separation in Ghanaian law?
No.
It's either you are married or
law, there's nothing like that.
And even if you are separated for 30 years, you are married.
So once the property is acquired.
No, hold on. We've talked about intention. Even if you go and live with another woman, you are married. Once the dissolution comes, the court, everything comes into contention. The court will examine the evidence.
Very well. Very well. So let's now move into another area when it comes to customary law. Sorry, my kids are disturbing here small. So in customary law, how does polygamy affect property rights between spouses? How is property divided when a customary marriage ends? I have 3 wives. I acquired property with all of them. Now the marriage has fallen on the rocks and we are separated. I mean, we are divorced. Let me put it divorced because we don't know separation in Ghanaian law. What happens to the sharing of the property by the courts? I'm playing the devil's advocate. I'm asking for the Ghanaian, a local Ghanaian woman who married to a man with other wives. How does the court deal with such polygamy?
I believe in polygamous marriages, divorce will come one after the other. It's not. It's very unlikely that, let's say, all three wives will gang up to divorce the man at the same time.
It may happen.
In such situations,
it may happen.
It means that, it's possible. Yes, you can't rule it out entirely, but it will mean that then there's a serious problem with the man. But I think what will happen, what will be the natural course of things will be that maybe one spouse, one of the wives will decide to leave. Will decide to leave, and then the other will follow, and so on. So at every point in time that one of the wives decide to leave, the court will determine just that wife's rights at that point in time. You get it?
Yes,
so
I get
that
it.
wife will then say that I contributed in buying or acquiring property A, and this was my contribution. Once the court is satisfied, then the right of that wife relative to property A will be determined. So it will not, the court is not going to say, well, there are some other two wives, so I'm sharing the property. Once they are not living, they are in the marriage, theirs will not come up. It is the one who is living whose rights will then be determined.
Okay. Thank you very much, Senior. Let me ask just two more questions, and the next 10 minutes we'll open up for everyone to also ask or contribute to whatever discussion we are having. I want to ask two questions related to death and inheritance. Death and what rights does a surviving spouse have when their partner dies? Or how is the property distributed under the intestate succession law, PNDC law 111? Or can a spouse be disinherited by a will?
Let me together. I've lumped them all together. So of course, it depends on whether the person died testate or intestate. So died by leaving a will or by not leaving a will.
Okay.
If they died intestate, they did not leave a will. Law 111 is what will determine. The wife has a percentage, the children have a percentage, the family has a percentage. Normally I do it, the family is 25, the wife is about almost 20 something, the children are about 56 or thereabout. So yes, the law did it in fractions, but I've tried to change it to percentages.
Yeah.
So there's that. Of course, the matrimonial home is not included in the distribution. That one, the law reserves for the surviving spouse and children. If they are surviving spouse and children. Now, if there was the person died testate, the court would normally abide by the will unless there was no provision for the wife or some of the children. Then the court would come in and say that, no, you can't do the will and leave your wife out. So whatever. There's this also thing that has also come into the jurisprudence now, where even we assume that properties were jointly acquired during marriage. You know, in some time past, like when I started practice, when the man dies, it's 100%, then they'll share it and value the full property. But as we were going on and growing, you'd realize that certain changes were coming. So now you will see that they've written 50% of house number so and so, to show that there is not the man and another person jointly owned the property. So you would see that in letters for administration applications where some sharing is determined. Of course, it is challenged. It can be challenged. You might have, especially where there might be children and there might be a stepmother who might not have had children, or there might have been a younger wife or something. You would see that sometimes the children will come in and say, no, she's not entitled to 50% of the property because the property was acquired before she came into them or came to marry the person or something. So these things are open to challenge. At the end of the day, again, the courts will determine. You have to show that the property actually is marital property. It was meant to be jointly acquired and all those things. The courts will determine it. So yes, even when it comes to upon death, those issues can still arise where you still have to show the contribution. Of course, children don't have to. All they have to show is that, yes, the contribution was made by maybe their parent, because of course, if it's for, let's say, their mother and it was property that was jointly acquired by their mother and their father, they are also entitled to show that, well, our mother contributed this much to the property and we are her beneficiaries, and so we are entitled to this much. So all those things will come. So now you have people bringing in caveats and whatnot, and the courts would issue their rates and whatever and resolve the matter after God knows how long. But it also goes through the process.
I'm grateful, Senior. Let me ask one question about cohabitation to Senior Kennedy. Cohabitation, informal relationships, let me put it that way. Do cohabiting partners have property rights similar to married couples? Do they?
Yes.
For example, a girlfriend or boyfriend claim property after a long-term relationship.
Yes. If they can, if the cohabiting couple can prove actual contribution. In the case of cohabitation, you must prove actual contribution, and that one, the contribution is straight.
Very straight.
Show exactly what you did. For marriage, the contribution is wide and relaxed. Okay. So many things can count as contribution. But with cohabitation, you must really prove actual financial contribution. I believe most of us have heard the recent promise to marry.
Promise to marry 200,000 K.
Yes, where the lady was able to prove actual contribution, and she was given, a portion of the property. So that one is more like, well, this is what I have done, and I want it. You see, in marriage, it is about sharing marital property to the parties to the marriage. What counts towards marital property is the intention with which they acquired it. So even if one party paid all the money, but the intention is that we are acquiring a home for our marriage. So you don't worry, I will pay. Use your money to, pay chop money, feed the house. I will buy all the property. So with marriage, it's very relaxed. Cohabitation is very strict because you are getting exactly what you put in. There's nothing like marital property to be shared. Ghanaian law doesn't recognize cohabitation and all that. So all that we are looking at is, what have you done to deserve a portion of this? But once you are able to prove it, you get it. That one, because our laws are against unjust enrichment for somebody to put in money and then the other benefits without any contribution. So definitely, once you are able to prove your contribution, you get a share of the property.
Thank you, Senior. So one last question I want to ask before I open the floor. Can a spouse stop the other from selling a marital property?
Absolutely.
Susan, okay.
Absolutely.
I
It's
want the
marital
lady to start.
property. It's
I think.
marital property. You see, you didn't say it, but you said marital property.
Oh yeah. I said marital
Yes.
property and it's spouse.
So why should one person go and sell what is belonging to the two of us? So yes.
All right. Thank you. Senior, you want to?
And the Lands Act deals with it, correct?
A case in point is Kwenyehia versus ADB, Agric Development Bank.
Okay.
The woman was in the house. Bankers from ADB came. We are coming to take over. Your husband took a loan from us.
Mortgage.
He used the house as mortgage. He has failed to pay. We have a court judgment. She sued. She sued the husband, the bank. Her case is that I partly own this house with my husband. Yes. And so he cannot, unilaterally take a loan with this property without my consent.
Yes.
And so to the extent that I did not consent to the collateral, the court should set it aside. And it was done. The court agreed with the woman that being a part owner, the bank needed her consent before accepting the collateral. And so for the bankers on the platform, when you are taking landed property or even any property as collateral, look at the nature of that property. If it is a marital property, then you need consent from the other spouse or spouses if it's a polygamous marriage. So the one spouse cannot just dispose of marital property without the consent of the other. If you look at Section 47 of the Land Act, there are provisions on disposal of such properties.
Spousal properties.
Yes, you need the consent of the other spouse. And it says in writing, consent in writing. So don't come and say, I told her, I told him, and he shook the head and said yes. No, it should be in writing. Consent in writing.
That is deep, Senior. I think I'm more blessed today. I've learned so much. I don't know. I see over 21 to 22 persons participating in this dialogue. The floor is open now for questions. If you can hear me, everyone, please just just unlock yourself and then speak. Ask any question. Mr. Felabi, Mr. Kwiku Apia Dankwa, Professor Manolate, also for Bequeen, of Adumako. Some comes in the iPhone and all that. The names do not appear. I see Senior Felix. Sister Gloria Ampoma is also here. Please ask your questions. I see Philippa Adu Amuako. Anything that you don't understand, please open up and ask. Osofu Tete has put another
yes, let me deal with that question.
Yes.
What Osofu Tete wrote that the interstate succession law identified three categories of persons or persons of interest.
Yes.
Spouses, children, and the family. See, the bit about the family is tricky. We had all thought so until there was a case in court. The family felt that after the spouse, the children, they were the next. And the court said, no, that is not what the act says. The act says under customary law. So you have spouse, children, and then dissolutions under customary law. So it is the custom that will determine whether it goes to the family or it can even go back to the children, especially with patrilineal families or patrilineal inheritance. The family ends up getting nothing. The areas in which the family ends up getting something are the matrilineal inheritance systems. So let's note that the Act doesn't mention family. It says under customary law. So we look at the customary law of the deceased and find out that when we take out the spouse and the children, who is next? The successor. And so
Customary
customary law
successor.
will choose the successor. And
If it's
if it is
surviving parents also
patrilineal,
come.
it will normally go to the children. The first child is likely to inherit the father. And so it may go back to the children. So let's correct that impression.
Okay. Thank you, Senior.
And let me add, of course, unless they are surviving parents, then the 25% is split between the inheritance by customary law and the surviving parents. If there are no surviving parents, then the
surviving parents,
is evolved according to customary law. Yeah. There's a question, and the next part of that question is if
the part 2,
yes, if he dies testate, what would the assumed responsibility to vary the will make provision for the missing persons. Now, it's not just a missing person, it's a dependent person. So if you have older children who have lived their lives and have their own, they are not dependent on you, and you decide that, as for these, my children, I've given them what I can give to them in life, but they are not going to benefit from me in death, it is your right. However, you can't do the same to your little child who is still in secondary school, for example, and say that I didn't like my wife when the child was born, so I don't give that child anything. The courts will step in. So it's dependent. And you can't say also that, well, let's say your wife was dependent on you for a livelihood and you've died and you have decided that I'm going to punish my wife in death, so I don't give her anything. The courts would also step in, especially if the wife can prove that she was dependent on the testator during his lifetime. So the courts would look at it. Yeah, but the family is not mentioned in the dependencies. That's the customary family. This is the Wills Act, so custom doesn't come.
Thank you, Senior. The also Tete also has some questions before. I don't know if Senior Kennedy can help us address it. He asks about how about marriage under Mohammedan law? Does it change anything regard estate distribution after divorce?
Yeah, if I answered that.
Given that Mohammedan marriage law is grounded somehow in Islamic law, which is clear. But I think that has been answered already.
Yes.
Yes, but maybe you can just hammer on it. Just
the only twist to it is when it comes to divorce, it's been answered. It is about whether or not there's a marriage. And our laws accept Mohammedan marriage. So that is the only thing. But the twist is if it happens to be death, assuming it is the man that is dead and he had 4 wives, and as he has taken his full, slots under Mohammedan marriage, taking all 4 wives. Now, if this man dies, the law says that 1 house goes to the spouse and children. So what it means is that all the 4 wives plus all their children are going to just take 1 house. Even if the Alaji had 50 houses in Accra, they are entitled to just 1.
Okay.
And then the rest will be distributed by the formula in the Act. So that is the only twist that is there with, ordinance, 1 man, 1 wife. That is I think that was what was in the mind of the framers of the PNDC law 111.
Yeah.
But after it's been passed and operationalized, you realize that it makes Mohammedan marriages worse off, because if the man dies, let's say Alaji has about 6 houses in Accra or across Ghana, the 3 or 4 wives and all their children are just supposed to take 1. And then the rest is distributed by the formula in the Act. That's a bit unfair. It's a bit harsh on them. But as things stand now, that is the law.
Okay.
And I must add that it can also apply to customary marriages where there are multiple wives.
Exactly. Exactly.
That's good. I think the Presbyterian who is marrying the Muslim will take a caution from this. I think he wrote the last part of his question. He said he knows a church member who is getting married to a Muslim or something like that. Also, if you can hear us, you advise accordingly. Anyway, we still haven't gotten any questions. So far, I think we've digested everything.
I think
there's a hand up.
Basanio's hand is up.
Oh, I can't see the hand. Where is he? Where is he?
It's
Mr. Basanio.
Yes, sir. Good.
Yes.
Good evening,
Let's see your
NUPS G.
face. Let's see your face more.
No, I'm not in the position to show my face. Unfortunately, I'm on phone.
Okay, so you proceed.
Yes. Just maybe two quick questions. Or maybe let me get a clarification first before I ask my question. So in Ghana, most of us typically marry twice. When I say we marry twice, I say we do the customary at home, and then we'll go and do the ordinance.
Yeah.
I don't know whether in law which one supersedes the other. I'm asking because by the same law you're supposed to register the customary, from what I understand, but that typically doesn't happen. So in the villages where they marry customarily without going to register, what happens to this? Do they still fall under all that we are discussing, or it has to be registered first before you can benefit from these types of distribution? Then my other one is about I'm married. We acquire properties, let's say 4 or 5, and I decide to bequeath one of them in my will to, say, my nephew or my brother. What happens? Will the law come in to say because it was acquired during the marriage, it was, aside the spousal home, it will still be taken and given to my wife, or they will find a way to share between my nephew or brother and my wife? I have another one, but maybe after this one, maybe we can discuss. Thank you.
Okay. On the registration bit, Mohammedan marriage requires registration to be valid, but customary marriage, no. Once it's contracted, it's contracted. Whether registered or not registered is valid. So that's the distinction.
Yeah.
Now let Susan address
Sorry.
the second part.
Just clarify for me. So virtually all of us who marry twice, I'm sure when I say I will marry twice, I'm sure that's what I'm saying. Which of them will be valid?
Oh, okay. Let me. Okay, so when you do the engagement and then it's followed by the wedding,
it's not engagement. It's marriage.
Oh yes, I'm coming. I'm addressing it. So that's how we
call it.
We say there's engagement, then the wedding follows. Yes, the engagement is the customary marriage. It's valid. But the moment you do the wedding, in law, we call it mutation of the marriage. You transmogrify the marriage. You change its form from the customary. So there's always only one marriage at a time. So you only transform the marriage from customary to ordinance, but there's always only one marriage standing.
Okay, yes, so thank you very much for that clarity. I asked that because I've seen instances where when there's divorce, typically the woman will go and give the drinks to the family and they say they are divorced. They don't follow through to do the court one, which means the marriage will still be subsistence even though they have brought the drinks to the family. That's what I wanted to clarify.
Yes, that's the right situation. Yes, the ordinance one will still be existing.
Thank you.
Exactly so. But you said you had another question.
No, there was a second question on the Basanio, raise the second question again. Let Susan.
Okay.
Yes.
So which was the second? Because I thought all have been.
So the second one relates to that are acquired properties, maybe 10.
Okay.
Your nephew. Okay. Yeah.
Good. So yes, if there's one thing about wills, you can only give personal property. You can only devise personal property in your will. So you can't go and take, for example, family property and say that I'm giving my family property to my wife in your will. It will be struck down. You can't also go and say it is my wife's property. So, but because I am the man and I am Ogboro, I'm going to give it to my nephew. Your wife can challenge it once she's able to prove that it wasn't even your personal property, it was joint property. The court will strike down that gift. So, we normally as lawyers, when somebody brings in property and what, we always want to be sure and careful that this property you are devising to somebody is your personally acquired property belonging to only you. If it belongs to you and your wife, then you have to maybe do a joint will where the two of you will devise the property to a person of your joint choice. Or you can come out and say, this is my percentage in the property, and I want to give that percentage to this person. So and you know, there's a funny thing about Ghanaians where as soon as somebody dies, we assume all the property that we see around is for sometimes most likely the man. So there have been times I have had to put categorical statements in a will that this particular house is not mine. It belongs to maybe my wife, and it was acquired by her, and I have no interest in the property. So that it is categorically stated in the person's will, before you end up having family members coming to say that not all the properties have been listed in the application, or the property belongs to him and he didn't say it or something. So yes, you can't just get up and give jointly acquired property to somebody of your choosing. No.
Okay, thank you, Senior Susan. I think offer your hand is up.
Sorry, can I just ask a follow-up on that one?
Okay, follow up.
My apologies. Yeah. So, Susan, assuming I put the house up in my village for my mother, you know, you spoke about intention. The house is in my village, and I'm sure my wife knew that I was put up for my mother. Now I am gone. Can she still come back and say that she contributed to putting up the house in the village, and so she's still entitled to a part of it, even though my will has clearly indicated that it's for my mother?
Okay, so that's another scenario. Remember that if she is alleging, she must be able to prove that actually she contributed. It would be a matter of proof, because this is property in your will, and the courts would presume that it was personally acquired until proven otherwise. So yes, another thing that you can also do is to actually put the property in the name of your mother, so that it is clear that the property is for your mother. And there's also the presumption, because it's your mother, you have given to her by gift. For example, even if it's your personally acquired property, you did everything and you gave it to your wife or your child, there's a presumption of advancement. The idea is that you wanted to give it to them. So there are those issues, but it is best to clearly state the intention. So either you give it to your mother by gift or something, so that when you are not there, it's not confused as part of your property simply because it came out of your resources.
Thank you very much.
All right. Sanyo, thank you too for your questions. I see offer comments hand was raised. Senior, if you are here, let's get your question.
Yeah, so if just as Basanio asked, if I acquire the property and I give it to my mother, which is written in the will, now my mom is no more, and I'm the one administering her estates, what happens to that property too? Is it also part or considered as property acquired under marriage, or how do we term that one?
Well, let me say this. In administering your mother's estate, the property is not for you. You are only in
An administrator.
an administrator's position.
Yes.
And administrator is supposed to immediately transfer the property to the one who is entitled to it.
Yes.
And so if your mom died, interstate, then we revisit PNDC law 111. That is, the first question is your dad alive? As in the surviving spouse of your mom, is the person alive? Where are your other siblings, the children? So if your mom, you built a house in your hometown for your mother, if the intention is clear, everybody knows that this house, you did it for your mother. Then your mother now dies. You've taken letters of administration to deal with the property. Your duty is to quickly use, if is by letters of administration, quickly use PNDC law 111 and transfer the interest to those who are entitled to take it. If your mom died having made a will, we use the will to distribute the property. It is where the administrator, you are not doing your duty. It's like you feel that if you're me and see and you would that is where the issues come up, because as the administrator, the property is not for you.
Senior, are you clear on that? Over, are you there?
Yeah, it's okay.
Okay, very well. Thank you. I think we should be bringing our discussion to a close. It's 8:33 now. I don't know if people have questions, any more questions to ask. If not, we'll be giving our closing remarks. We've learned a lot today, starting from ownership of property to contribution to divorce and property sharing, to jointly acquired property, customary law marriages, cohabitation, death and inheritance, and all that, property registration, and other stuffs, Mohammedan and all the things that we can imagine. In fact, we've learned so much about intentions today, that everything borders on the intention. And you cannot just go to court without proof, because documentary evidence is the best form of evidence. And so we are learning so much today. Before I draw the curtain, I would like to call on our resource persons to give their closing remarks, and then we will take our closing prayer and we call it a day. Please, any of you can begin. Auntie Susan.
Okay, since you have mentioned my name. So what I would say is, be clear on what you want in the marriage, so that you can also be clear on what you are entitled to if unfortunately the marriage has to come to an end. So be open, be clear, know what you are putting in, know what you are taking out. And we won't say you will get a divorce, but in the unfortunate circumstance that it happens, at least there will be some clarity on who gets what. That is what I'll say to end.
We are grateful, Senior. Mr. Ifa.
What I will say, from where we sit and what we see, you see a lot of mischief, a lot of deceit when it comes to property and then marriages. I think that we should just be sincere with ourselves. A number of instances, couples act because they trust the other partner. They are in love. They feel that we should buy land and build. How much is it? They said the land is 50,000. I have 30. The other spouse brings 20. You know that this person has contributed. Yet people will come to court and lie.
Yeah.
And so I sometimes, I mean, you wonder.
We
There
are
are
all
instances, ladies who get married to a man, you know that when you got married, this man has built his house. Yet they would lie. And so that is my sometimes one thing I have been wondering what is happening. I think that we should just be sincere with ourselves. Where are you going with properties and things like that? So let's be sincere. If you know your wife contributed, your husband contributed, I think that even as soon as the divorce petition is filed, settle. You know, the properties are 4, 5, and you want to take all. Why? Where are you going with them? So I think that let's all be sincere in our dealings. You know, if you know that this person is entitled to this, just let it go. Because some people don't forgive. You take it. If they didn't get it in court, they will go and get it somewhere. So my position is that let's be sincere with ourselves. Let's also be mindful. The fact that you are divorcing doesn't mean all of a sudden you are now enemies. And even America and Russia, they collaborate in a number of things. China, America, they collaborate in a number of things. So what is it that makes as Christian you handle Christian divorces and you wonder?
It's a whole lot. I'm doing one in Medina District Court, just as you are seeing. The man keeps saying that he built the house when in fact, he had the house before they got married. Meanwhile, it was the brother of the woman who hosted them the first 4 years of their marriage. The guy has forgotten all of a sudden. And that he built the house before the woman came in.
You just
liar.
lie. Just
Everything shows that
the
he's
whole
lying.
property.
Yes.
What for?
And it was the brother who was the carpenter for the whole project. Yet he's saying he built the house before the woman came to his life. So, and they are all Christians. They had a wedding ordinance. The pictures are all exhibited. Very, very interesting. So, Senior, we thank you for everything. God bless you for your in-depth understanding of the law and your, precision to answering all our questions and everything you've shared with us. I'm sure the 22 panel, participants, we've learned so much today. I want to thank the leadership of the group for the opportunity to also do this, to moderate and also to serve as resource persons. And so we want to say thank you and close the chapter for today. We hope that we'll have similar legal discussions in the future as leadership may determine in the course of time. Thank you. I'm sure also for who started with us may end with us. So I don't know if executives have any announcement to give before the closing prayer. Mr. Nkama.
After that, you best sign the memo for taking your time to enlighten on some of these things. We are so grateful for the opportunity. Just as you said, we pray that we'll get some of these discussions going on so that we learn more from you, the councils. And so we are grateful. So for we are Willie Waha. And I'm saying so for
but I hope we met your expectations and
oh yes, it's good.
All right.
So, Katkis, senior Katkis.
Papa Bequin.
Fire quite.
Yo, it was your fault. Yeah, they won't bite. Let us pray. And so, Heavenly Father, we want to say thank you once again
Finishing.
yɛhen kɛse yɛsɛ yɛda wase a na ɛsɛ na ɛfata ɛna anwummere yi nso mma yɛba wo no ase wonam saa adekyɛ yi so ama yɛsua ade ɛno nti yɛkɔ akɔda yɛni yɛretu yɛn ho ɛhyɛ wo nsa yɛn mpaebɔ no sɛ dom yɛn fa yɛn si wo nwini ase ɛna anwummere yi nso mabambɔ soronko a wode dɔm ma mma no na fa bi hyira yɛn na anwummere yi yɛne yɛfifo nyinaa yɛne adɔfo no nyinaa yɛne yɛabusua nyinaa ɛsrɛ wo saa ade pa kyɛ yɛn so ama yɛn ahoɔden soronko yɛtumi ɛde abɔberɛ a ɛsɛ wo din kronkron anuonyam yɛda wase titiri nso ma yɛn nuanom a ɔnam wɔn so ɛwɔ adekyerɛ yi ho ɛsiane ɔfama ho a ɔmowɔ ma kuw yi nti yɛn mpaebɔ no sɛ to nhyira nso gu wɔn so na hyira wɔn nsa ano ndwuma yɛda wase wɔwɔ a yɛ nyame agya ɔba ɛne nkronkron din mu nti
Amen.
Amen.
Amen. So, I would like to say bye-bye to all. Senior Ofelabi, thank you for the recording and everything.